have with us Mr. Arvind Jadhav, ex-chairman KT, Chief Secretary, ex-Chief Secretary Karnataka. May I request you, sir, to please come up to the dais. We have with us Mr. K Pathak, Member, Board of Revenue, Bihar. Sir, if you could kindly come up. We have Mr. Nagaraja, the CEO, Center for E-Governance. Alok Prasanna Kumar from Vidhi Center for Legal Policy and Research, Delhi, and a practicing advocate in Bangalore. We have Raunaq Jaiswal from the Jindal Global Law University. Raunaq, if you could please come up to the stage. So again, just to give a brief setting before we start off with the speakers, there's a very important paper by Douglas North, a very well-known economist. In 1990, he published a paper for which he won the Nobel Prize. It basically talks about that it's not only the people who man institutions, but institutions themselves and their design that determines the outcome of those institutions. So it's important, as Sudhir also pointed out yesterday, that we talk about institutional reforms in the sense of their organizational design, the rules and procedure they follow, because all of this ultimately go into shaping the outcomes of these institutions. And naturally, this relates to policy decisions because there has to be some policy outcome at a broader level which will manifest itself in better outcome by these institutions. So with that brief introduction to this session, may I call upon Justice Reddy to please come up and give the first speech.
Good afternoon, ladies and gentlemen. Let me start by congratulating Kapil, Mohan for this, and Government of Karnataka for this nice conference. Kapil is a batchmate and a good friend. And it's a good idea that we all should learn from each other, meet at least once a year, if not more frequently. That takes me to the next point. Every conference has a takeaway. I also propose that as a takeaway from this conference, if no other state is coming forward, we would like to host the next second national conference in Bihar. Please don't get scared of coming to Bihar. We can do a very good job of it. It's a nice state. I can feel some of the people are not, it's a good place to come. So, Jadhav sir, it was your initiative, which was an idea developed by Kapil. I wish to carry forward. And I would not take much time. I would just give you a brief about what we are. We are a board of revenue in the original British sense. We have carried on that legacy. And for the past 2 days, I was thinking whether we can emulate the Karnataka model or not. So there are problems in emulating Karnataka model because we look after all the cases, just like Karnataka Appellate Tribunal does, except that we have a specialized tribunal for commercial taxes, and we have a specialized tribunal for the land revenue cases also. We are a revisional forum essentially. What happens is that original order is passed by a collector or a deputy collector. Then it goes to the appellate forum, which could be divisional commissioner, and then at a revisional level, it comes to the Board of Revenue. We were constituted under a Board of Revenue, Bihar and Bengal Board of Revenue Act 1879. So we are that old. And to emulate Karnataka model, we have to think of changing or deleting, amending the act, or maybe doing away with the entire act. We also do a lot of other works which in your state is being looked after by Karnataka Public Service Commission. We look after a lot of administrative work, departmental examinations, departmental promotions. The chairman, who's my senior, is a chief secretary rank officer. And he is generally looking after all those administrative things. I, on my part, when I joined the Board of Revenue in November, I was given all the land ceiling cases. There were 147 land ceiling cases given to me in November. I have no hesitation in confessing that I have disposed of all of them, and there is no pendency in my court. And the last order was passed in this month only. So all 147 cases, and I was very happy to note that Justice Reddy also just reconfirmed my view that no cases should be dismissed for default. Wherever the courts, wherever the lawyers, they're not appearing, the parties are not appearing, you still go ahead and pass an order on merit. The earliest case pending in the Board of Revenue was 1978, which I disposed of in 2017, and the newest case was of 2016. Much of it, as it exists, lies with the lawyers, lies with the advocates. And particularly revenue is a very, very specialized area. Unless you have done the work in the field, you have seen the field, it is not possible for any appellate member or a tribunal member to appreciate what the original court has said, what the revisional, the appellate court has said. So I disposed of all the 147 cases, and when I sent my report to the Chief Secretary, I nearly got a panic call from him. He said, "What, kya Pathak, you disposed of all 147 cases in one order only?" I said, "No, sir, it was a 1200 pages judgment running into, it was not a single order. I passed 147 orders running into roughly about 1200 pages of judgment. Last 3 or 4 months, I have been hearing the court every day, morning court, evening dictation, morning court, evening dictation." Now, from the dictation, yesterday I could recall a speaker who noted that, who observed that one judge said, "Stenographer absent, bail denied." Stenography, as one speaker yesterday mentioned, is a dying art. And it's a fact. The stenographer thinks that he can do steno in English or Hindi. In your case, it was English or Kannada. But when he brings the thing, he will come back, and you will not know what you dictated and what he has come back with. So I said, I got a computer operator. I said, I don't need stenographers. A computer with 2 screens. He was sitting on the system. I was having the screen with me. As I start doing the dictation, that way I saved 5 hours. First you give 2 hours to steno for dictation. Then he takes 3 hours to develop it into English. Then you take another 1 hour to correct it. So instead of 5 hours, I used to dispose of a judgment in 2 hours sharp. So that is how revisional forum should work. I mean, we are not supposed to open a plethora of the procedures that has evolved in the district court or say high court. Were we to follow the same model, where was the need for us to carry on with the tribunal or a board of revenue? We should dispose of our cases in a very time-bound fashion. Why should we have a lower court record? Why should we call a lower court record? You ask the lawyer, please convince me, why do you want me to call for a lower court record? It will take 2 years, 3 years. Fortunately, in my case, since the cases were pending since 1978, all the LCRs were already received. Very few which were still not received, I used to ring up in the morning and tell the collector that please send the records. But then why should we have those records? All you need at the revisional forum, all you need at the Board of Revenue or at a tribunal level, all you need to see is the original court order, the appellate court order. Where is the infirmity? Learned friend, please point out. So, this is how, in my view, a revisional forum should function. Of course, beyond us, there is a high court. In Bihar, as I mentioned, we have a land reform tribunal headed by a retired high court judge. There is a member administration, member judicial. So what I'm trying to say is that one important point that we forgot to mention, that we have amended our act also, that all appeals should be disposed of within 6 months. All revisional cases by the Board of Revenue should be disposed of within 3 months. So that's a part of the amendment, because you can't have a Board of Revenue which has cases since 1978. Or in Karnataka, I was told that 1948, there was a case of 1948. You can't have that kind of a pendency at our level, at this tribunal level. And much of it lies with the advocates. They take time in arguing. I was reminded that in the sealing cases, they argue for 1 hour, 2 hours. I would keep reminding them that please point out the merits. And I was reminded of a joke when a lawyer was arguing the case since morning. It went till post-lunch session. The judge was now running short of patience. He was looking at the wall. He was losing his concentration. So the lawyer said, "My lord, don't look at the wall. I still have many more law points." So judge was now, he got fed up. He said, "My dear learned friend, what made you think that I'm looking at the clock? I'm not looking at the clock. I'm looking at the calendar. Please finish the arguments today. I'll be happy. Don't take it to the next day." So if the lawyers are, at the revenue board, I keep telling them, just give me the points of merits. Where do you want me to intervene? Justify it. And that's how the things came up. So I would say that at our level, we should amend the act also. I don't know whether Karnataka Appellate Tribunal has a time limit for disposal of cases, but we should have those time limits. Like Bihar has done, we have amended the act. All revisional cases before the Board of Revenue should be disposed of in 3 months sharp. So that we should not take the entire judicial process into tribunals. Otherwise, what's the point of having tribunals? So that's all. I would like to finish my thing with again an invitation, renewing my invitation that next year we should meet in Patna. Thankfully, good.
Thank you, Mr. Pathak. I think KAT probably wishes to thank you also for extending that invitation, that offer for the next year's conference. And Mr. Pathak has added a very important point as to whether the laws should specify time limit, and that can probably be one of the concerns for the policymakers who are thinking about changing the procedure of tribunals. With that, I'll call upon the next.
Ladies and gentlemen, I am Raunaq Jaiswal from OP Jindal Global University. Firstly, I would like to thank the Karnataka Appellate Tribunal for organizing this impressive conference and for inviting me to be a member of the esteemed panel. The tribunals, which are constituted as a specialized body to adjudicate on special matters, which require a high level of technical expertise. Proponents of the tribunal system have argued that the tribunal system is necessary to overcome the pendency problem by having expert judges. However, there is an inconsistency with the Karnataka Appellate Tribunal Act 1976 with respect to Section 3, which says that the chairman shall be an officer not below the rank of divisional commissioner. It is pertinent to note here that the constitutionality of a tribunal like Intellectual Property Appellate Board and the Competition Commission of India has been challenged in the courts. In the matter of IPAB, the head of the tribunal was an executive appointee, which the Madras High Court held to be perverse. The chairman is, in effect, an executive appointee, but judicial independence is a vital condition that ensures that judiciary deliver justice without being prejudiced by any outside consideration. And this ideal is essential to the preservation of the rule of law. By allowing for appointments to be made by a majority of executive members, these bodies cannot function as an independent body insulated from any political influence. Critics, such as Mr. M.C. Chagla, pointed out that appeals from tribunals to High Court could be denied by legislation, forcing a man wronged by a tribunal to go all the way to Supreme Court, Delhi, to seek relief. In United Kingdom, the court, referring to its earlier decision in Findlay versus United Kingdom 1997, restated the requirements of independence and impartiality. On independence, the court declared that in establishing whether the court or tribunal was independent, regard had to be made entirely to the manner of appointment of its members and the term of office, the existence of guarantees against outside pressures, and the question whether the body present an appearance of independence. On impartiality, the court restated the proposition that the tribunal must first be subjectively free of personal prejudice or bias. Second, it must also be impartial from an objective viewpoint. That is, it must offer sufficient guarantees to exclude any legitimate doubt in respect. With these judicial pronouncements in mind, I would like to posit that the administrative function of the tribunals be hived off from judicial functions, which in respect is to create a separate body that manages only the administrative functions, and the judiciary is completely different from the administrative part. In effect, everything that is concerned with passing orders or decrees is into judicial compartment, and anything outside should be managed by the administrative department.
Thank you, Raunaq.
Good afternoon, everyone. As with most things in life, everything has a plus and a minus. As the last speaker, I have the privilege of having the last word in this discussion. But also as the last speaker before lunch, I know nobody wants to listen to me for more than 5 minutes. So I will not repeat anything that has been said by far more eminent speakers than me. Let me just briefly give you an idea of what we did at Vidhi, and one major takeaway that I think we should all keep in mind when we're talking about policy and tribunals. At Vidhi, we had the opportunity to study two very major tribunals set up by the central government, the TDSAT and the IPAB. We had a chance to work with the central government on the issue of merging tribunals. We also studied the impact of the Supreme Court's judgments on all tribunals, specifically the NTT judgment, which had a major impact, I think, on a whole set of tribunals. I don't want to go into the specifics of each study or what specific findings we made, but I want to focus on one important aspect, and that is this. Everything that we discussed today in terms of policy and who has to make what changes to the functioning of the tribunals depends very much on who actually makes the changes. When I say this, I mean that the control, the supervision, and the management of tribunals is currently a mess in this country. Our study showed that tribunals have become orphans. They are neither part of the judiciary, they're neither considered part of the formal judiciary, nor are they considered the core concern of the parent ministry which is in charge of them, and they're nobody's problem. I think that is a very sad state of affairs. I personally don't know the exact situation in Karnataka. We haven't done that study yet, but from what I was able to make out, this was true of a large number of tribunals across the country. I think if we have to start talking about what changes need to be made to tribunals, the conversation has to first start by saying that tribunals are not an alternate to courts. They are as much part of the court system as the High Court, Supreme Court, and the district judiciary. They should therefore be treated as part of the judiciary and constitutionally should enjoy the same protections and the independence of the judiciary. Justice Mohan Reddy made a very important point about having a central institution. I think the judiciary as a whole has also functions as an institution for the issues of the judiciary. You have conferences of chief ministers and chief justices where the chief justice and the Supreme Court judges can put forth their points. You have the collegium which deals on an equal basis with the central government on issues of appointment. And you have various committees set up by the Supreme Court which are also concerned with the issues of the judiciary. Unfortunately, there is no such body for tribunals. We can't create a body for the tribunals out of thin air, and I don't think the government will be taking up these issues because they're just not on the list of priorities. I think the most important fundamental reform that tribunals in this country need is to be considered part of the judiciary and enjoy the same level of protection and changes. protection and benefits of such reform. Coming back to a point as to why do we really need to do this, I think we have come to a situation where there is a crisis in the Indian judicial system. I know everybody keeps saying there's always a state of crisis, but I think this is something that has come to light recently. Specifically, I want to point to two very interesting studies, one carried out by Daksh and one carried out by the Cornell University, which actually show that contrary to popular belief, there is no litigation explosion in India. Recently, the chief economic advisor said there's a litigation explosion in India. Unfortunately, that is absolutely untrue. What we instead have is large-scale judicial exclusion, litigation exclusion. We have people being unable to access judicial institutions for various reasons. And even when they have an opportunity to access, they are not choosing to come to the judicial institutions. These are issues which I'm sure more people are doing research. I just wanted to highlight this here to say that this is a problem we'll have to start dealing with now. The theme of this conference is access to justice. The point of this conference is to find out how we can increase access to justice. And I think the starting point of further inquiry should be that, yes, there is a huge problem in accessing justice. And any reforms that we consider, whether in tribunals, whether in courts, and in any other judicial institution, has to start from the point of view of how do we make them more accessible to people. So with that, I would like to conclude my remarks. Thank you very much for giving me this opportunity to speak.